As I say in the consultation paper, we've been quite anxious that we don't open up the areas upon which the Civil Courts Review made recommendations when it reported in September 2009. This review covers the question of expenses, which we deliberately did not cover in the Civil Courts Review because we were aware at that time that Lord Justice Jackson's report on expenses or costs in England and Wales was imminent. We've been told by a number of solicitors who operate in the commercial sphere that clients who have a choice as to whether they should litigate in England and Wales or in Scotland are more attracted to litigating in England and Wales, where they might be able to recover up to 90% of the legal costs which they incur should they be successful in the action. In Scotland, the rule of thumb is that they will be able to recover somewhere between 1/2 and 2/3 of the expenses which they incur. And it is therefore said to us that it is a disincentive to litigating in this country. On the other hand, there is a clear tension between making litigation or making the courts more accessible. If one increases the financial risk in the event of being unsuccessful, then it might be said that one is inhibiting access to the courts. There are probably two aspects of the imminent changes in England and Wales which have the potential to impact in Scotland. In the first place, damages-based agreements are going to be allowed in England and Wales, and as I mentioned earlier, they're at the present moment not allowed in Scotland. And further, that in England and Wales, in personal injury actions, the unsuccessful claimant will not be liable for the successful defendant's legal expenses. That might give rise to a situation whereby a person with a good personal injury claim in Scotland against a party against whom jurisdiction can be established on either side of the border feels that their best interests are served by raising the proceedings south of the border rather than in Scotland.